Hello, everyone. Welcome to our Week 10 lecture and topic, International Humanitarian Law. We are now very close to the end of the semester, which is exciting, I'm sure. This is our second last content week. So next week we'll be doing International Criminal Law, and that is effectively our last week of content. And then after that, for our final weeks of tutorials, our final week of tutorials rather, we have the Assessment 3 moot. So just also a reminder in relation to the Assessment 3 moot, on your week 12 Canvas page, if you go to before class, I've put a video there which goes into some aspects of the moot. It's supposed to be a little bit of a tips and tricks, some approaches to mooting for international law, and I also talk about how you should think about maybe structuring your written submissions and also structuring your oral submissions as well. So I hope it's a little bit helpful too. Importantly as well, in week 11, you have the due date for your written submissions, which is obviously quickly coming up, so please keep that in mind. In probably halfway through week 10 this week, perhaps after our Tuesday tutorials, for those of you doing Tuesday tutorials, we'll have the release of the assignment 2 marks as well. So we've got a few things on the horizon in the next few weeks. So hopefully we'll be concluding the semester with a lot of things going on and a lot of hopefully interesting points to conclude our course. So let me start. I'm sorry, I always just have to check that I'm actually recording. I am. Okay, so let's progress the slides. So this is what we're looking at for the lecture today. We're talking about the sources. We'll go into the types of armed conflict relatively briefly before turning to the fundamental principles. We'll look at some persons and objects under protection as well, some prohibited means and weapons, some special protection regimes, and finally some new issues. So once more, I've tried to kind of set this out in the narrative that your textbook runs. Some points the textbook goes into a lot more detail, which then I won't really address too much. Then there's some other areas where I think your textbook could use a little bit more assistance in, which is where I weighed in there. So engage with your textbook first, I reckon, then come back to this and I can try to supplement some of those points that you'll hopefully learn through the textbook as well. So let us start talking about our sources. And this is obviously a little bit of a historical discussion as well, because, for many of us who know even just cursory knowledge about human history over the last, few hundred and more years, there's been persistent violence and conflict for a very long time. However, after many centuries of very violent warfare, there were slowly efforts to try to regulate these bloody conflicts. To try to regulate weapons initially. So quite famously in the 1868 St. Petersburg Declaration, there was an effort to regulate weapons, and then the efforts to protect civilians from the conduct of hostilities in the 4 Universal Geneva Conventions, which we're more interested about today, alongside their additional protocols as well, which was all kind of described in toto as international humanitarian law. So this is kind of like more or less what we are looking at today. And we'll go into the content of these rules and principles in some detail because they're important not only for the humanitarian function that they're allocated, but they're also supposed to serve the necessities of war as well. Because historically, as well as today too, in a lot of the narrative we see around contemporaneous conflicts, there's this constant struggle to balance so-called military necessities with humanitarian factors. And so this is where the jus in bello, which is the law of armed conflict, is not mixed with the jus ad bellum, which is the right to war, which is the law prohibiting the use of force. So we're interested here in the jus in bello rather than the jus ad bellum. So we also looked at that distinction in our tutorial last week as well. So even though as we've learned, that aggression is prohibited in international law. We still have a law of armed conflict, which includes rules and principles that regulate how an armed conflict can be conducted lawfully. So even though the idea of the international system and the international law kind of regime is to prevent the occurrence of armed conflict, we still have the rules that need to be followed if armed conflict does break out. And the history of where this came from is again in that kind of awful human history of ongoing and consistent violent conflicts, especially in the imperial and empire era in Europe, probably most importantly. And for our purposes, one of the really vital early conflicts, which kind of gave way to major efforts to deal with the violence coming out from wars, was the Battle of Solferino in 1859. There was an individual called Henry Dunant who came upon the violent aftermath of this battle, of the Battle of Solferino, and he was quite shocked by what he saw. It was the first time that this Henry Dunant had come up close to the horrors of war, at least the aftermath of them. And he was one of the early humanists who argued that this violence was unnecessary and catastrophic, and subsequently went on to found the Red Cross. And this was a important development, as we'll soon see, because the International Committee of the Red Cross has kind of like been central to international humanitarian law. And Dunant and other influential pacifists like him were really important in those early campaigns to adopt like regulations that limited the suffering of the wounded, that tried to limit the horrors of the war. So the International Committee of the Red Cross was established just a few years after in 1863. Then the first Geneva Convention for the amelioration of the condition of the wounded in armies and in the field was in 1864. And then we had the 1899 and then 1907 Hague Regulations, which aimed at protecting the wounded in the war as well. And early on in these efforts, it was mainly states from Europe and a few from Latin America that participated. So there was just 16 states that participated in the first Geneva Conference, and that resulted in an agreement on the principles that emphasized the care of wounded individuals on the battlefield, regardless of their nationality. And then the Hague Peace Conferences expanded these regulations and included rules governing naval warfare, which were then confirmed and amended in the four 1949 Geneva Conventions and the two 1977 additional protocols, which we'll be going into some detail on. And the Geneva Law, which was the law that came from the Geneva Conference, this was mainly concerned with the protection of the victims of armed conflict, while the Hague Law focused a little bit more on limiting or prohibiting certain means and methods of warfare. The effect of the additional protocols that were adopted in 1977 to the Geneva Conventions, the idea was also to kind of merge both of these laws into a more cohesive whole. And the background to that, for the Geneva Convention in 1949, then those additional protocols, was that period after World War II where there was an increasing attempt to try to, mitigate and, well, certainly prevent the horrors that occasioned humanity in World War II. And just like with the founding of the UN, there's a lot of diplomatic conferences to try to agree on rules to care for the sick, the wounded, and prisoners of war as well. They explicitly intended to broaden the scope of those earlier Geneva Conventions and the Hague Regulations, and the 1949 Geneva Conventions enshrined rules on protecting civilian populations during war and under foreign occupation, and also generally regulated international armed conflicts. So it's supposed to be kind of an amalgamation of the earlier conventions in the international humanitarian law arena. And one of the major innovations of the 1949 conventions was the regulation of non-international armed conflicts. And you'll see this often acronymized as NIAC, so non-international armed conflicts, in Common Article 3. And this was important too because previously, before this stage, most war and conflict was envisioned between state parties across international borders. So this was one of the earlier moments where there was an attempt to regulate warfare in like intrastate, so a non-international armed conflict. And this Common Article 3 has become one of the most important provisions of international humanitarian law, especially because today most conflicts are non-international in nature. Obviously, you know, we know there's of a number of contemporaneous conflicts which are international, but still there are a number that are still non-international in nature as well. And because all states are party to the Geneva Conventions, they are bound by Common Article 3. And the International Court of Justice as well has found that this provision has a fundamental character which reflects like an elementary consideration of humanity and as like a minimum yardstick binding in all armed conflicts. So this Common Article 3 is very important, coming from the 1949 Geneva Conventions. Now, historically, after that, the 1949 conventions, what then was occurring in the world in the decades after World War II was obviously the Vietnam War, along with other struggles against decolonialism and wars of liberation as well. And this highlighted the need for further warfare regulation because the struggles of guerrilla forces and non-state armed actors were not really envisioned in kind of a concrete, holistic manner in the previous conventions. And so the two additional protocols from 1977 were adopted in light of these kind of decolonial wars. And the Vietnam War was one of the most important influences on this. And it brought to the fore the issues of liberation wars and the status of guerrilla fighters as well. And at this time, one of the main objectives of the countries of the so-called Global South was to have fights against colonial domination and occupation and racist regimes recognized as international armed conflicts. And one of the most important developments in the Additional Protocol 1 related to the rules of the conduct of hostilities, which was Articles 35 to 60, and that was supposed to update the Hague Regulations of 1899 and 1907, and the experience of the Vietnam War has kind of like informed that update, that Additional Protocol 1 in regulating the conduct of hostilities across Article 35 and 60, which was supposed to kind of reaffirm the conduct of armed forces in their hostilities to further enhance the protection of the civilian population. And it elaborates on the principle of distinction, which is one of our fundamental principles, which we'll talk about further soon, between civilians and combatants, and between civilian objects and military objects, and prohibited indiscriminate attacks. It also contained a definition of military objectives. It spells out the obligations to take precautions in attacks and also against the effects of attacks. And the practices that were shown during the Vietnam War focused the drafters' attention, the drafters of the additional protocols, also on topics such as starvation as a method of warfare, area bombardment, and the destruction of the natural environment, which were key tactics of the United States invasion forces against Vietnam. So then, Additional Protocol 2 focused on more explicitly on non-international armed conflicts, which included a set of rules that apply to conflicts between states and non-state actors. And so this is how we can maybe differentiate those additional protocols at the time being, is that Additional Protocol 1 is more extending the rules of the Four Geneva Conventions, whereas Additional Protocol 2 is focusing on those non-international armed conflicts more specifically. So let's have a look at those different types of armed conflicts now, which your book goes into this in a lot more detail. And it also makes a bit of a distinction between not only international armed conflicts, non-international armed conflicts, but then talks about like hybrid conflicts and the like. There is quite a bit of debate whether these are useful categories especially because this concept of hybrid warfare, which has become very popular more recently, especially since the 2014 war in Donbass in Ukraine, this has become a very popular concept. But then there's also been a lot of critique saying that really all conflict has been hybrid, for as long as possible. There's always been matters of, media being involved as well. And, other elements of hybrid warfare that you see today has also, had echoes in the past, although obviously it takes different forms. So here I'm really just focusing on the ways that, international humanitarian law cuts a distinction between certain types of conflict. And, as we've kind of already hinted, that distinction between these two main categories, international armed conflicts or IACs, and non-international armed conflicts or NIACs, this arises out of the history of the regulation of war and armed conflicts by international law. Um, and because since like around the time of the Treaty of Westphalia in 1648 up until the Second World War, just as I hinted at before, this was really only just, or at least international law only recognized international wars or interstate wars. And this was a consequence of the fact at this time that international law really only saw relations between states as international law, and so it ignored things or ignored regulation of matters considered to be within like domestic jurisdiction. So internal armed conflict or civil wars were not considered to be like real wars in the strict sense of the way that international law understood them. And the laws of war could only apply to civil war where there was some kind of recognition of the belligerency of the insurgent party. So the application of international law to the internal situation into an internal conflict was not automatic, and it was only if there was a recognition of the like state-like qualities of an insurgent party. Um, so again, quite a relatively rare occurrence. And so this idea of the regulation of war, the laws of armed conflict, only applied to international conflicts between states, and other conflicts were generally not recognized. Now, the extension of international regulation to internal armed conflicts changed decisively after World War II, just like I gave a bit of a brief overview before, especially in the context of anti-colonial wars of liberation. So the four Geneva Conventions of 1949, they decisively established that international humanitarian law would apply to conflicts involving non-state entities, but they also then made a distinction between the different types of conflict of our international armed conflicts and our non-international armed conflicts. And the Article 2 common to all four conventions specifies that the conventions apply to all cases of declared war or of any other armed conflict which may arise between two or more high contracting parties. And the International Committee of the Red Cross, who is seen as like the gatekeeper of international humanitarian law, and is also an important source of international law in and of itself. If you go to the International Committee of the Red Cross website, they have really great resources, and they also have you might call it a database in a sense, or at least some kind of categorization of customary law in terms of international humanitarian law. So they're a really important voice, and they have often called to extend all of the conventions in their entirety to internal conflicts. But historically and still today, this has been rejected by most states. And so that's why we only had that single provision, the Common Article 3, applicable to the armed conflicts which are not of an international character, that crosses territorial borders. So that has also been the background of the definition between the international and non-international armed conflicts. So it's important when you are analyzing a armed conflict, you have to then, determine, well, what is the kind of armed conflict? And this classification, you have to, in a lot of senses, especially in thinking about international humanitarian law, is kind of fall on either side of it's international or non-international. And I mean, the political economist in me kind of, has a lot of grapples with these kind of distinctions because I really find it very hard to think about any conflict. And well, maybe thinking about like any non-international armed conflict, which hasn't got involvement from internet, other state parties. So if you think, even most probably obviously perhaps of like the Syrian war, which on the face of it is a non-international armed conflict in terms of, there was state government backed forces, there was non-state armed forces within Syria operating and fighting against each other. But obviously, there's a huge amount of international involvement in that conflict. Or similarly, if you look at the war in Sudan as well, that could also be seen as a non-international armed conflict. But then there's also a large number of international parties who influence the outcome and the courses of that conflict. And similarly as well, Myanmar is another really good example where you have, a military dictatorship who is in conflict with a large number and a really large number of non-state actors within the country, but then there are a lot of international actors that are involved on either side. So this distinction is presented as kind of two nice siloed categories by international law, but I think these are distinctions which are really quite hard to make. But I mean, besides that, um, once we've kind of classified, again, in international law, once we've classified whether it's an international armed conflict or a non-international armed conflict, that has ramifications as to then what parts of international humanitarian law will apply. So, if it's an international armed conflict, the entirety of the Geneva Conventions of 1949, the Hague Conventions from 1899 to 1907, and Additional Protocol 1 apply. And these contain hundreds of articles which establish a detailed body of rules relating to the conduct of hostilities, as well as those concerning the protection of persons who do not or who no longer take part in hostilities. However, if you then are categorizing and you find it's a non-international armed conflict, these rules are a lot more narrow and a lot more limited. So again, these are commonly, the rules are mostly found in Common Article 3 of the Geneva Conventions of 1949, the provisions of the Additional Protocol 2 of 1977, and then there's also some elements of the ICC statute, which we go into next week. So that's mostly Article 8. And so Common Article 3, it provides some basic protection to those who do not or no longer take part in hostilities, and it does not regulate the conduct of hostilities. The Additional Protocol 2 only has a quite limited number of substantive provisions, I think less than 20 or so, and those parts of the ICC statute, which we'll talk about in more detail next week, also deal with a non-international armed conflict. And they are supposed to, both of them are supposed to extend the rules protecting victims of conflict and introduce some modest rules on the conduct of hostilities. But they do fall short of the length and breadth of international humanitarian law rules applicable in international armed conflicts. But importantly, our customary international law does provide for a broad set of rules that do also help here, that help govern non-international armed conflicts and fill many of these gaps. And the International Criminal Tribunal for the former Yugoslavia, the appeals chamber in the Taudik case, took this position that customary international law actually fills a lot of these gaps, and they held that the rules of international humanitarian law applicable in international armed conflicts concerning the protection of civilians or people who like are out of combat, because they're injured, for example, as well as civilian objects, as well as rules around the prohibition on certain means and methods of warfare also apply in non-international armed conflicts. And the International Criminal Tribunal for former Yugoslavia, or the ICT. Why they justified their position on the basis of state practice, and that elementary considerations of humanity and common sense would make it preposterous that weapons prohibited in international armed conflicts could be used by states to put down rebellions in their own, by their own nationals in their own territory. So even though, for us, in terms of our, being international lawyers, looking at international humanitarian law, it's important to classify what kind of armed conflict it is because the relevant treaties will be different for each type. It's still vital to keep in mind the really important rule from the Taudik case that the gaps in the non-international armed conflicts are often plugged up by customary international law. So let's talk about some of these fundamental principles, which usually, are common really across both types and much of it because of our customary international law. And we'll go through each of the ones here that I have on screen. Not in a huge amount of detail because I think your textbook does quite a good job with them as they are. We'll go through each one by one. And a lot of these have emerged not just from the rules within the Geneva Conventions and the Hague Regulations and the additional protocols, but also due to the consistent practices of states and opinio juris. So many of these practices, which are described here in the fundamental principles, also gradually emerged as our customary rules. And then a lot of the time they were then codified in our treaties like the Hague Regulations, the Geneva Conventions, and the additional protocols as well. But all of these fundamental principles of the law of armed conflict, the principles of humanity, distinction, proportionality, military necessity, the obligation to take precautions or the prohibition on unnecessary suffering, enjoy that status of customary law. And these apply in international armed conflict and non-international armed conflict. Their goal is to humanize warfare without challenging the justifications for the initial aggression. And that is also a separation between our jus in bello and the jus ad bellum. So again, we're thinking about jus in bello here. So these fundamental principles help maintain the balance between military necessity and humanitarian protection. So to determine the legality of an attack in terms of how it's carried out, all principles as well as the specific regulations have to be observed. And in tutorials this week, we'll be going through a developing kind of stepwise progression of a conflict where you will have to determine legalities of whole different attacks by different actors. So it means thinking about through these fundamental principles. It means thinking about the specific regulations that might apply. And importantly, where these also come from, in the nuclear weapons case, the ICJ identified two of these principles informing the normative landscape that governs the conduct of hostilities. They said there were cardinal principles that contained in the text that constituted the fabric of humanitarian law, and they noted of them there is firstly an aim to protect the civilian population and civilian objects. That establishes a distinction between combatants and non-combatants. And also states must never make civilians the object of attack and must never use weapons that are incapable of distinguishing between civilian and military targets. And so therefore you can't cause unnecessary suffering to combatants. And then it's also prohibited to use weapons that causes them such harm or uselessly aggravates their suffering. And so states do not have unlimited freedom of choice in the weapons they use. And both these kind of principles embody the balancing of the kind of foundational principles that we have here. And the first of them, distinction, limits military operations by carving out, based on humanitarian concerns, the categories of persons and objects that may not be attacked, and with respect to which various precautions must be taken to avoid harming them. And then the second, which is around unnecessary suffering, restricts certain forms of harm suffered by those who participate in hostilities, and to that, for the so that the conduct of hostilities is effectively regulated. And so most of these rules, our fundamental principles, come from these so-called major cardinal principles, which are enunciated. They didn't come from the nuclear weapons case, so they're just enunciated by the ICJ there of this distinction and, no unnecessary suffering have kind of broadened to these broader points. And we'll go through these quite briefly one by one and go in a little bit more detail. Well, where in other places do we see them? So the principle of distinction, our first one here, this determines who and what can be targeted in the conduct of hostilities. This is also something that's explicitly noted in Article 48 of the Additional Protocol 1. And it's emerged as a cardinal principle, like we mentioned our ICJ nuclear weapons case. That's not only in the treaty but also a fundamental part of customary law. So it really underscores civilians and civilian objects are not lawful targets, while military objects and combatants can generally be attacked lawfully. So unless civilians participate in hostilities directly, they're legally protected from belligerent attacks. And having said that, there are very limited conditions, and only proportionate where collateral damage to civilians and civilian objects can be lawful. So Article 25 of the 1899-1907 Hague Regulations, it doesn't use specifically the word civilian, but it says the attack or bombardment by whatever means of towns, villages, dwellings, or buildings which are undefended is outlawed. And regarding international armed conflicts, Article 57, subsection 2, B of Additional Protocol 1 stresses that only direct armed attacks against combatants and military objects are lawful. Then in non-international armed conflicts, Article 13, subsection 2 of Additional Protocol 2 prohibits attacks on the civilian population and treating civilians and civilian objects as an object of attack. And in international armed conflicts as well, Article 57, subsection 1 of Additional Protocol 1 stipulates that in the conduct of military operations, constant care shall be taken to spare the civilian population, civilians, and civilian objects. So it's quite a robust framework to try to prevent harm to civilians. Now, proportionality is enshrined in Article 51, subsection 5b of Additional Protocol 1, which states that an attack which may be expected to cause incidental loss of civilian life, injury to civilians, damage to civilian objects, or a combination thereof, which would be excessive in relation to the concrete and direct military advantage anticipated. So it puts the damage caused by military activities into relation with the military advantage and require that the effects of the means and methods of warfare cannot be disproportionate to the military advantage. So this, again, explicitly balances military necessity with humanitarian considerations. And it's a common understanding that this phrase, direct military advantage, refers to the advantages of the operation as a whole and not separate parts of the attack. So military necessity, while it speaks of the criteria to choose a military target, this law of proportionality lays down the limits of specific military actions to neutralize a target. And so on that point of military necessity, which is our third principle here, actions that are necessary to accomplish a legitimate military purpose and are not otherwise prohibited by international humanitarian law can be lawful. In both customary law as well as treaty law, the only lawful military purpose is to weaken the military capacity of the other belligerent party. And Article 23, subsection G of the 1899-1907 Hague Regulations prohibits the destruction or seizure of the enemy's property unless such destruction or seizure be imperatively demanded by the necessities of war. So even the just the wanton destruction of the enemy's stuff isn't permissible unless it's actually a necessity of war itself. Now, our fourth principle here, that of humanity, um, this is also obviously a very vital one, and states have adopted norms prohibiting cruel and inhumane treatment of opponents, especially regarding prisoners of war. And we also have protections for the wounded, the sick, those who are shipwrecked, and also non-combatants. They all have protection under this principle of humanity. So for non-international armed conflicts, this principle is found in our common Article 3, which also states that there's a prohibition on the inhumane treatment of all those persons not participating in hostilities. In international armed conflicts, Article 75, subsection 1 of the Additional Protocol 1s, it emphasizes the humane treatment of individuals without discrimination. And this principle also enjoys customary status as well, which is applicable not only to states but non-state actors alike. Now, finally, the prohibition on unnecessary suffering. This is also the principle of precaution, and this was initially set out in Article 2 of the 1907 Hague Convention, and it provides that given the presence of a military target inside an undefended town or port, the military commander must take all due measures in order that the town may suffer as little harm as possible. And Article 57 of the Additional Protocol 1 states that it's incumbent upon the warring parties to do everything feasible to verify that the objectives to be attacked are neither civilians nor civilian objects and are not subject to special protection. So these are some of our, maybe the most important central fundamental principles of international humanitarian law, again protected by custom, and also have their enunciation in our instruments of international humanitarian law as well. So now let's go into who do these principles apply to? And this is also another matter of distinction between combatants, non-combatants, civilian and military objects as well. So this is where we then have to start thinking about, what is classified as what. And originally, we have to always kind of consider the history here that the whole point of the law of armed conflict, of international humanitarian law, was to spare civilians and the civilian population from the consequences of war. So the principles of distinction, again, generally prohibits direct attacks against civilians. There are other provisions of the Geneva Conventions and the additional protocols that also addresses other specific protected groups or objects. And this is medical personnel, cultural property, as well as natural environment. And their protection is also linked to the broader regime of protecting civilians and civilian objects. But there are actually more specialized provisions about these specific groups and objects that differ from the general protection of civilians and civilian objects. So I will talk about the protections for medical personnel, especially because it's so relevant to the International Committee for the Red Cross. And we'll also go a little bit more into detail about the special protections to the medical units, the cultural property, as well as the environment as well. But before we get there, the most usual fundamental distinction you have to make is that of combatants and also non-attached combatants. So we'll talk about these categories now. And the rules that regulate the status and the treatment of combatants, and also combatants who are removed from the field of combat, such as prisoners of war. In international armed conflicts, we find these rules principally in the Third Geneva Convention and also Additional Protocol 1. There's a considerable overlap between the statuses of, who's combatant and then who's out of the field of combat as a prisoner of the war. Article 4 of the Geneva Convention 3 specifies upon whom a prisoner of war or POW status is assigned. And so, and then, therefore, who gets the protections of the Third Geneva Convention. And this provision identifies prisoners of war as persons that have fallen into the power of the enemy and belong to a number of different categories. And it does go through quite a number of detail about who those people could be. But the main primary one are the category of people who are the armed forces and militia and volunteer corps that form part of the forces of a party to a conflict. And if you have a look at that provision, there's a lot of other categories, and they usually also consist of people who are adjacent to the main military effort. And so it's also important to keep in mind that even though there's a considerable overlap between combatants, people who are doing active fighting, and prisoners of war, there's quite a big overlap between the two. They're not totally exactly the same. So all combatants are entitled to prisoner of warfare status upon capture, but not all those entitled to prisoner of war status are necessarily combatants. And so, for instance, the uh, definition. So this you can see this when you have a look at the definition of who a civilian is for the purposes of the rules of conduct of hostilities in Article 50, subsection 1 of Additional Protocol 1. And it says, and I'm quoting here, a civilian is any person who does not belong to one of the categories of persons referred to in Article 4A1, in subsection 2 and subsection 3 and subsection 6 of the Third Geneva Convention, and in Article 43 of the Additional Protocol 1. So the people who fall outside those sub provisions of Article 4A, so that's the ones that weren't mentioned in this definition of civilians, which is 4A, subsection 4 and subsection 5 of the Third Geneva Convention. These are members, kind of combatants that accompany the armed forces and members of crews of the merchant, marine and civil aircraft. These people are also entitled to prisoner of war status when captured, but they are actually seen as civilians rather than combatants. So they kind of straddle a difficult overlap between that category of civilians and combatants, but they enjoy prisoner of war protections. And this distinction is also important because it's only those who are entitled to combatant status who also can actually participate in hostilities. So this means that the people who are combatants actually are cloaked with some kind of immunity from domestic prosecution for ordinary, acts of war that are compliant with international humanitarian law. So these categorizations of people either as combatants, of civilians, and then the kind of ancillary groups are important. Not only who's prohibited from being targeted like civilians, who gets prisoner of war status, for example, but also who can actually participate in war, and then which then gives some kind of immunity for regular warring activities. And they're immune from domestic prosecution for those particular activities. And the treaty law as well of international armed conflict more broadly has been developed to try to expand the scope of people entitled to the status of prisoner of war. And will come back to talking more about prisoners of war in our special categories of international humanitarian law, obviously because it's also very topical today. And in these kind of efforts of different parties around the world, or different states around the world, in using treaty law to expand this status of people who are entitled to the protection of being a prisoner of war, alongside this broadening, has been a desire to ensure the persons who are rightfully entitled to this status are not arbitrarily deprived of them. And so Article 5 of the Third Geneva Convention says that if there's any doubt that arises to whether persons having committed a belligerent act and then fall into the hands of the enemy belong to any of the categories enumerated in Article 4, such persons shall enjoy the protection of the present convention until such time as their status has been determined by a competent tribunal. So even if there is kind of some uncertainty as to whether someone can enjoy the status of prisoner of war and the attendant protections that entails, then Article 5 of the Third Geneva Convention says, if you're unsure, they should have those protections. And this has also been controversial to, especially in the last 20 years, in terms of the practical application of this provision, because it's controversial to say whether and where and how so far doubt has arisen as to the presumption of prisoner of war status. So this was really important after the illegal invasions in 2001 of Afghanistan and then Iraq, because the United States captured members of the Taliban and Al Qaeda and didn't extend prisoner of war status to them, which was really controversial at the time. And they said that there wasn't actually any doubt, so that provision of the Third Geneva Convention, that provision of Article 5 didn't actually apply because they didn't have any doubt, that they were not entitled to that status. So they excluded the obligation of presumption of prisoner of war status under Article 5. And so that means then they didn't have that protection of prisoner of war status, which then, meant they could occasion, quite horrific torture and other interrogation methods upon them. But as many of you would have been aware, that the United States, as well as its allies, were highly criticized for this, because it basically, was effectively escaping international obligations to presume entitlement of a prisoner of war status in a situation where really, at the very least, there was doubt that existed whether they were combatants or not. And I mean, it really, in the most favorable interpretation to the United States, there was at least doubt that they could reasonably said to have been combatants in terms of, they were members of non-state actors who were fighting, which would seem on the face of it that they would have some protection. So obviously there's a very highly criticized application of this law, or non-application really. And then this law of status is even more controversial when we think about non-international armed conflicts, because persons there are not clearly categorized under applicable rules. So Common Article 3, which is, again, we spoke about as very important in regulating non-international armed conflicts, it talks about members of the armed forces, who could have prisoner of war status. And then Additional Protocol 2 refers to civilians as well. So it also, both of them together, does strike that, that categorization of these different types of persons, but there's no further elaboration on these legal categories under the various treaty laws around non-international armed conflicts. So there's actually no technical prisoner of war status in non-international armed conflicts in terms of the form it exists in international armed conflicts, with which has all the attendant provisions and the protections enunciated within them. And so the consequence is that those participating either on the state or non-state side, on the face of the treaties, are not entitled to combatant immunity under international law, and also that they might not have the same prisoner of war status or enjoy those protections. And this has also been the case because states have consistently rejected the claim that armed opposition groups, even if they fight in compliance with international humanitarian law, they reject that they can't prosecute them under domestic criminal law for their actions, which would be prohibited if they had a status of combatants. So that's why states have been reticent in extending that combatant immunity to non-international armed conflicts, which then also has impact on then, who can be prisoners of war as well. So the current law as it exists on paper, by laying down no rule of combatant immunity in non-international armed conflicts, leaves states free to immunize their own armed forces under domestic law while prosecuting armed opposition groups, even if they are undertaking international humanitarian law compliant acts, which also then creates issues of, who can be a prisoner of war. So these are some of the issues that you should, think about when we're considering combatants in these different theaters. Now, for civilians, civilians are obviously a category of people who were really focused on in most of international humanitarian law. And the four Geneva Conventions of 1949, they updated the pre-existing treaties and furthered the protections granted to not only civilians, but also the protections granted to combatants who are taken out of the theater of war because they're wounded or sick or shipwrecked. And that's talked about in Geneva Conventions 1 and 2, or if they're taken out of war because they're a prisoner of war, as we just spoke about, this is Geneva Convention 3. But then Geneva Convention 4 extended protections to civilians. And this was this is really the first treaty that sought to protect this category of persons in armed conflict kind of in total. Before 1949, civilians were in a more precarious position because their status was more regulated by custom, which was also prone to change in light of state practice, which is obviously very difficult. Now, in terms of the specific civilian categories, the most important one, perhaps we might be able to say, or the most a relevant one, or the one that enjoys the most protection, is that of medical personnel. So the original 1864 Geneva Convention, this was concluded to take care of the wounded and sick combatants of all belligerent states who were out of the battle. And the French of this, and many of you will know this better than I do, is hors de combat. I'm pretty sure that is not exactly how you say it, but it's out of the battle. So this convention was about taking care of those who were hors de combat. And, you can really tell of my very basic upbringing as soon as I try to pronounce anything French. But without medical personnel and medical care, these the people who had this kind of protection, this would have been totally meaningless, because if the medical staff didn't have protection, then, what's the point of giving protections to people who are sick and wounded, because, they're not going to be able to get the care they need. And so therefore, civilians and even military officials assigned to medical purposes, either temporarily or permanently, had a really high value in war due to their essential role in military care. And so they all enjoy protection, that is personnel, medical units and medical establishments. They enjoy protection and cannot be targeted lawfully. They're protected when fulfilling the medical duties in conformity with medical ethics. But if they do participate in hostilities, they do lose that protection. Then, if they fall into enemies' hands, they are not considered prisoners of war, importantly, and must be set free immediately. So they can use the distinctive sign of the Red Cross, and also the Red Crescent, the Red Lion, and even more recently, I can't remember what year, but I think quite recently, the Red Crystal, which guarantees their special protection. So they're visible to the enemy's forces. Now, turning to objects and thinking still along the lines of the medical personnel and medical objects, the medical units and objects are also really important to discuss here. And Article 8, subsection, or Article 8E of Additional Protocol 1 explicitly defines medical units as establishments and other units, whether military or civilian, organized for military purposes, namely the search for collection, transportation, diagnosis, or treatment, including first aid treatment of the wounded, sick, and shipwrecked, or for the prevention of disease. This term includes, for example, and I'm still quoting here, hospitals and other similar units, blood transfusion centers, preventative medicine centers and institutes, medical depots, and the medical and pharmaceutical stores of such units. Medical units may be fixed or mobile, permanent or temporary. So they shall be respected and protected at all times and are not to be the object of any attack. Again, their protection is lost if they're used to commit outside their humanitarian duties and functions, hostile acts, or acts that are harmful to the enemy, but only after due warning. Again, this is language which is very reminiscent of medical personnel addressed above. Now, I also bring this up because, as many of you know, from, engaging with contemporary conflicts, this is really a highly controversial issue. The protection of medical buildings and medical personnel has seemed to becoming increasingly irrelevant in contemporaneous conflicts, such as in Russia's invasion of Ukraine and most prominently in Israel's war on Gaza, where, as we've seen, all hospitals in the Gaza Strip have been destroyed in some capacity. There's been a huge number of medical personnel targeted and killed by Israeli forces. And you can see in this distinction of that, the protection of medical forces, medical units and medical personnel, they enjoy protection unless they participate in hostile acts. And then there has to be some kind of warning before they are attacked. You can see this dichotomy and this kind of issue between these two being played out in real time, where often the Israeli Defense Force has accused a certain medical unit or medical building as being a hub of hostile acts towards their army, and then they give them warning shortly before being attacked. I'm certainly one of many people and many lawyers who disagree with the categorization of these hospitals and medical personnel committing these hostile attacks and totally and utterly feel that they are absolutely illegal under international law. This is also something that I am quite personally impacted by, because obviously I was a medical doctor previously, and I still have many friends who are involved in theaters of war. So this, I think, is one of the more important categories of international humanitarian law, which I think for me, and I'm getting quite emotional speaking about this, is withering away really rapidly, which I think will have far and wide negative impacts for all of us. And so I think this is an important topic that you should also engage with and thinking about. Because, like I was saying, and getting back on to, these points more broadly, intentionally directing attacks against these, buildings, material, and medical units that, have the distinctive emblems of International Committee of the Red Cross is especially a war crime, but even without that, any kind of distinctive emblems of, medical care is a war crime in both international armed conflicts and non-international armed conflicts. So this is, a really important point. And so any persons who are wearing these, distinctive emblems, as well as, especially medical personnel, must not and cannot be attacked. Now, moving on to another important category is that of cultural property. They enjoy special protection in armed conflict as well. And you also saw, again, many of you maybe remember, I think about 10 years ago or so, when ISIS was destroying significant cultural property in Syria and Iraq. There was, huge uproar about that because well, not only just because of how wrong it appeared just for normal common sense, but also that cultural property has special protection in armed conflict. And so the two additional protocols of 1977 specifically has provisions that protect cultural property in international armed conflict and non-international armed conflict. And the Hague Conventions also have provisions for the protection of cultural property. and this kind of complements these Geneva laws. And the cultural properties protect in armed conflicts because it has this broader relevance for humanity. So it's that principle of humanity again, and because everybody contributes to the world culture. And destruction of cultural heritage is also a war crime in the Rome Statute, which we'll talk about next week. Now, finally, for this particular page and category, the natural environment is another really important area. And this particularly became really important since the aftermath of the Vietnam War, and especially because of the propensity of the United States forces to have widespread obliteration of the natural environment. No, yeah. Sorry, my little my cat's very concerned about that. I know it's not very nice, but that's right. So the after this context of the Vietnam War was really important in establishing the necessity to protect the natural environment. And the Additional Protocol 1 defined and stated that the natural environment enjoys direct protection, and it's important to be aware of the words it uses here. It says from widespread, long-term, and severe damage in international armed conflicts. And so there's been actually quite a lot of debate around this and exactly what it means, because it's unclear whether long-term is measured in like years or decades, and then does it exclude the short-term severe damage? But probably the better view here, and this is where when you go into these debates of what do these words mean in these treaties, and this is kind of quite similar in statutory interpretation as well, you should have in mind to the preparatory work, which, in our public law statutory interpretation might be like the, second reading speech. It might be this explanatory materials. It might be like the committees that are established to, create these or inform the bills that are going through. But for, international law in the treaties here for the Additional Protocol 1, if you look at the preparatory work, it seems that the drafters were actually thinking about really long-term damage, so in the decades. So this also has the impact that even though the really devastating environmental damage in the Vietnam War, and even in the Gulf War, when there's burning oil wells in Kuwait in the early 90s, even the deployment of Agent Orange, these kind of acts, even though for I think most common sense would consider this quite widespread long-term environmental damage, it would appear from looking at the preparatory work that might not even hit the bar of what the drafters were considering, which is quite problematic, especially in our era of climate change and wanting to maybe protect the environment a little bit more actively than perhaps in the 40s and 50s. And 60s and 70s, sorry, where this was also being drafted. But there's also, other elements of the environment that are protected for civilian objects again. And so that, usually hitting them rarely serves some kind of military objective, and they usually can't be attacked lawfully. And so there's some provisions too that indirectly protect the environment, such as in Additional Protocol 1, Article 56 talks about installations containing dangerous forces like nuclear power plants or dams, which can't be attacked. And again, this is a really significant contemporaneous issue where in Russia's invasion of Ukraine, you probably again saw a lot of media coverage around Ukrainian nuclear power plants and how the threat of Russian targeting of these nuclear power plants was a really concerning issue. Not only because of the obvious human immediate impacts, but also because of the widespread environmental damage that such an attack would obviously occasion. Now let's move on to the prohibited means and methods of warfare. And I think we maybe have about 10 or 15 minutes left, because I apologize. I know I've already been going for quite a while, but a lot of like international humanitarian law, as well as most of the areas we do in international law, in some places they have, a high semester course on these. So we are trying to squeeze quite a lot in. And as just a side note too, if any of you are interested in this area, the International Committee of the Red Cross, or just the Red Cross in Australia, they run really good courses on international humanitarian law. If you're a student, I remember they have student prices which are really accessible. I think I did one or two in when I was studying. So if you're interested, I think sign up to them because they run them relatively frequently from memory. Um, but anyway, so yeah, take a look at that. So for the prohibited means and methods of warfare, I'll just really touch on a few things relatively quickly because I mean your textbook I don't think goes into these in huge amounts of detail. Um, the so-called like Hague law, the Hague regulations, they regulate the use of means and methods of warfare to mitigate the so-called calamities of war. And this is actually kind of like the oldest branch of international humanitarian law. And its basic tenets, if we can put it in three kind of fundamental points, and just excuse me, I've got a door behind me, which I'm just closing because my cat's in the front of it and it's quite loud outside. So I'm just closing that. So these three fundamental maxims of regulating and preventing these calamities of wars is firstly that the only legitimate object which states should endeavor to accomplish during war is to weaken the military forces of the enemy, and that in pursuing this aim, these other maxims come in, that the right of the parties to the conflict to choose methods or means of warfare is not unlimited, and also the civilian population and individual civilians shall enjoy general protection against dangers arising from military operations. So this means that there are then prohibitions on what weapons can be used. And international humanitarian law has traditionally focused on prohibiting or restricting the use of weapons. Through the Geneva Conventions as well as the Hague Regulations, for example. So the parties to a conflict are restricted by not only these treaties but also customary rules in terms of the weapons they can lawfully use and in the ways they can use them. And the International Committee of the Red Cross has also, said as well, and it's important to, what the International Committee of the Red Cross say because often, they are one of the norm generators for customary law as well, and might be a starting point for broader state adoption and state practice. And they have said that military necessity cannot justify any derogation from rules which are drafted in a peremptory manner, that everyone should kind of agree on, that we should all kind of strive for. So this also applies to international armed conflict and non-international armed conflict. So it's important too, when we're thinking about these weapons, that also the fundamental principles that we've spoken about also applies. So a few of the categories of weapons that have some kind of regulation and some that don't. Firstly, inherently indiscriminate weapons. These are often restricted, whether they're offensive or defensive in nature, because they can't really apply that rule of distinction. So if this weapon is incapable of distinguishing between civilian and military targets, it's therefore prima facie unlawful. And this is also where this goes back to one of our cardinal principles in the 1996 Nuclear Weapons Advisory Opinion. This was noted. Nuclear weapons obviously being a good example of a totally inherently indiscriminate weapon. Now, weapons causing superfluous injury is also prohibited. So this means weapons that basically cause unnecessary suffering. And the origins of this rule is traced back to one of the early modern treaty laws in this area that prohibited explosive bullets. That was in 1868, the St. Petersburg Declaration. This was about explosive bullets, so bullets that would explode and shatter and put a lot of shrapnel in people, which was seen to be superfluous and producing unnecessary suffering. Anti-personnel mines is another weapon that has regulation. In the mid-90s, there was a protocol that was adopted by the parties to the Convention on Certain Conventional Weapons, or the CCW, three C's and a W, CCCW, the Convention on Certain Conventional Weapons. There was an additional protocol attached to that, which was in reaction to the epidemic of landmine injuries, which was continuing to occur in developing countries, especially long after the end of armed conflict. So you see this even like in Cambodia and in Vietnam, many theaters and many countries around the world which were theaters of war, anti-personnel mines still linger. And so this protocol adopted at that time prohibits the use or transfer of anti-personnel mines that are deemed undetectable or remotely delivered, and which can't be then also self-deactivated as well. Now, another group of weapons that came under scrutiny around that time were cluster munitions, and for kind of the same reasons, because these weapons contain multiple like sub-munitions within the kind of a dispenser, and they are dropped or ejected over and then disperse over a wide area. They were originally designed to target personnel or military material. During the Cold War, NATO powers kind of saw them as a way to stop the countries allied with the Soviet Union, the Warsaw Pact members, from their tank divisions advancing through West Germany in the event of a war between the two. So there was the thinking that cluster munitions would be a way to spread out a particular single ordnance into multiple. But because of these being often airborne and air-dropped ordnances, the munitions would frequently not detonate as intended upon impact with the ground, and they would stay there. And then they were often killing civilians, and especially children who would like pick up these kind of small objects, not knowing what they are, and they would explode with catastrophic consequences. The last weapon, just to note here, and I mean this is an exclusive or exhaustive list, expanding bullets. These are also ones which are sought to be regulated with some difficulty. These are bullets that expand in the human body. So they have like a hard envelope, but it is then kind of pierced with incisions. So once the bullet kind of goes into a body, it'll then open up and spread out, which again, goes back to some of those fundamental principles of military necessity, humanity, and so forth. And this was actually an issue which, and these expanding bullets are actually still in production today, but this was initially an issue in the late 1800s where British troops were using them in attacking indigenous people in the various theaters of colonial conquest they were involved in, and the soldiers actually did this themselves, where they filed down the tip of the round to reveal the lead core, so that when the bullet went into the human body of these generally indigenous people in various colonial contexts, the round would go into the body, and then the actual the lead would kind of spread out, and this was known as the dum-dum bullet, and that was named because after the factory near Calcutta that were manufacturing these kind of bullets that could be modified as such in this area called dum-dum. That's DUM. And again, this is still used today, and also seen to inflict superfluous injury and is prohibited under customary international humanitarian law. Now, in terms of methods, there's kind of three major methods of warfare that kind of bring up really difficult and important legal issues. That's starvation, reprisals, and the destruction and seizure of property. These are all important areas, which again, your textbook kind of briefly touches on. But firstly, with starvation, modern international humanitarian law really importantly prohibits starvation of civilians as a method of warfare. So deliberately depriving them of food is prohibited under international humanitarian law. And again, this is derived from the principle of distinction, because when you put someone under siege, you can't distinguish who's getting food or not. this rule is in both additional protocols, and it's also considered customary law in international armed conflict and non-international armed conflict. And also the Rome Statute, which we'll talk about in international criminal law next week, also has parts that talk about the intentional starvation of civilians as a method of warfare is a war crime as well. And there has been cases around the world of domestic criminal law also um, uh, being used to prosecute people who were involved in the crime of starvation in non-international armed conflicts. Um, so this also, related to this, prohibits the attack, destruction, removal, or rendering useless objects that are indispensable to the survival of the civilian population. And this is like not only food, which is directly related to starvation, but also agricultural areas, crops, livestock, drinking water, and irrigation systems as well, which is for the specific purpose of denying them for their sustenance value to the civilian population or to the adverse party, whether in order to starve out civilians, causing them to move away, or for any other motive whatsoever. This is also something you see in the Myanmar conflict, where the military dictatorship there attack agricultural resources as well as water objects in particular areas, because Myanmar has a number of various ethnicities in the country, which are often, associated with armed groups that are in war against the government, and the military forces will attack agriculture areas, crops, livestock that they justify as providing food for the military factions against them, or the armed factions against them, but of course also broadly affects civilians as well. And again, many of you would also be highly aware of the very publicized destruction of agricultural areas, drinking water in Israel's war on Gaza as well. I think the last time I looked, it was something like 85 to 90% of all agricultural areas, most drinking water has been destroyed. And also, everyone is probably very well aware of the siege and methods of starvation being implemented by Israel in that war as well. So these are, significant international humanitarian law issues, which are still lively today in most of the conflicts we are seeing. Now, the second method of warfare here, reprisals, these are like countermeasures. So they cover actions that would otherwise be unlawful, but that in exceptional cases is considered lawful under international law when used as an enforcement measure in reaction to unlawful acts of an adversary. So this was traditionally, reprisals were regarded very, historically as a method of enforcement of international humanitarian law. But generally now, international humanitarian law prohibits many types of these reprisals, though it doesn't outlaw them altogether. So the Geneva Conventions of 1949 prohibit reprisals against protected persons and objects in power of the enemy. So reprisals are prohibited against the wounded, sick, and shipwrecked, prisoners of war, and civilians as well, and the property of civilians of an adverse party to the conflict or an occupying power, and against medical objects as well. Finally, the other method of warfare, which is prohibited in some shape or form, is the destruction and seizure of property. The 1907 Hague Regulations, Article 23 G, says that it's prohibited to destroy or seize the enemy's property unless such destruction or seizure is demanded by the necessities of war. So this also came up when we were speaking about the necessities of war. And then the Geneva Convention speaks about, extensive destruction and appropriation of property that's not justified for military necessity is a grave breach of the Geneva Conventions. And this is especially concerning that which is protected by the Geneva Conventions, which is, again, as we mentioned, our fixed medical establishment, mobile medical units, hospital ships, medical transport, as well as medical aircraft, and also objects and property in occupied territory. And Article 53 of the Fourth Geneva Convention protects real or personal property belonging individually to private persons or persons of an occupied belligerent state or to other public authorities. So to constitute a grave breach of this area of the destruction and seizure of property, there's four things that must be satisfied, as a kind of a whole of these different discordant articles. Is firstly, that destruction must be extensive. Secondly, it must be not justified by military necessity. Thirdly, carried out unlawfully, and fourth, wantonly. So just without care. And there are more specific rules about occupied territories, but we'll talk about that when we go into our specific discussion in terms of special protection regimes on our next slide. So let's go over there now. So we've already spoken a little bit about prisoners of war, but I'm kind of expanding on this point too, because obviously prisoners of war is a very important topical issue today. Not only do we see a large amount of discussion and media coverage in terms of both prisoners of war that Ukraine and Russia have in their particular conflict, but also in the prisoners of war and captives that are held in Gaza and also in Israel as well. So this is a really important topic which receives a huge amount of attention today. So I thought it's also relevant to go into it in some more detail and kind of recap and summarize the points that we've already spoken about before. We'll then touch on the law of occupation too, before concluding with a couple of new issues. So, like we mentioned, that detention of the prisoners of war has a large number of provisions of international humanitarian law, and the purpose of this is to ensure there's humane treatment of people deprived of liberty. So, apart from the relevant international law provisions which we've been discussing, there's also rules in customary international law, domestic law, and also human rights law, which we've also spoken about in previous weeks. So even though, again, always going back to that distinction between military necessity and humanity, it's obvious, almost so beyond discussion, that there's no kind of justification of military necessity by a belligerent for inhumane behavior towards people who that it has within its power. So there always has to be humane treatment, and this is explicitly referred to in key provisions of international humanitarian law, which for prisoners of war and captives that cannot be modified by reference to the exigencies of military necessity. So again, the Third Geneva Convention states very clearly that prisoners of war must at all times be humanely treated. And this must be observed with respect to the conditions of detention as well, because the people who are deprived of liberty are in a position of special vulnerability, because the preservation of their physical and mental health and their very life is determined on the detaining authority and the people who are detaining them. So the explication and the imperative for humane treatment means that the authority or the power that holds them must provide an adequate response to not only their physical needs. So this is things like, food, water, clothing, hygiene, medical attention, but also psychological needs. So this means also relations with the outside world. If there's, religious and other cultural activities of the persons detained. So these are also really broad, important factors that we're adding on to our conversation from just before. So the Geneva Convention 3 and 4 include a really detailed set of provisions, which we have briefly noted before, on the conditions of detention for prisoners of war and even civilians as well, and elaborate a range of other aspects of the respective internment rights. And we've kind of noted some of these provisions before. Now, an issue here too is that Common Article 3 doesn't include provisions as such on the conditions of detention in non-international armed conflict. But the second additional protocol has tried to rectify this in some way for situations in which it's applicable by means of provisions that apply as a minimum with regard to persons deprived of liberty for reasons related to armed conflict, whether they're interned or detained. So these provisions and this regime around prisoners of war is really important to be aware of. And also, one of the fundamental reasons why international humanitarian law was created in the first place, and obviously still, a very topical issue today, which is really worth being, well across of. Now, the second special protection regimes in international humanitarian law is that of the law of occupation. And this is referring to a certain phase of international armed conflict where the belligerent has overpowered an adverse party and then taken control of its territories. But there actually hasn't been a final outcome of the war. So this occupation is supposed to be a transitional phase between the end of active hostilities and the formal conclusion of the conflict. And it's a period where the foreign armed forces or the occupying power are responsible for the administration of the territories belonging to the defeated state. Now, this particular branch of international humanitarian law was basically, barely discussed for the many decades after World War II, except in relation to Palestinian territories under Israeli control. But this has more recently kind of reversed in recent decades and has become now a much more prominent part of international humanitarian law, which is also why I wanted to bring it up. And this is especially because this was a source of contention following the invasion of Kuwait in 1990 by Iraq, the international administrations in Kosovo and East Timor in the late 90s, and then also the illegal invasions in Afghanistan and Iraq and the subsequent occupations as well. And so the implications and the scope of the law of occupation has, there's been a lot of renewed interest in it. And it also is an area of law that has evolved over time. And there's a lot of different treaties that kind of shape it and the rules applicable to it. The first kind of relevant multilateral treaty that's still in force today was the Fourth Hague Convention on the Laws and Customs of War, which was adopted in 1907, along with its regulations. And the most important part that regulates the law of occupation is Section 3 of the Hague Regulations. This is Article 42 to 56, which specifically deals with occupation, addressing this military authority over the territory of the hostile state. It wasn't ratified by a whole number of states at the time, only 37, but it's been recognized generally as expressing customary international law. And its norms are therefore binding upon all states. So in this this part of the Hague Regulations, Article 42 talks about, the territory that's considered occupied, and it's placed under the authority of the hostile army. And this provision is usually considered as providing the core definition of the notion of occupation. This is Article 42. And this question, there's then a question that comes from this is to what is the level of territorial control required to trigger the application of the law of occupation? Again, and this is a point which is open to a lot of debate, which we'll come back to address as well. But there's several provisions that support the view that the level is relatively high. So Article 42 of the Hague Regulations states that the occupation extends only to the territory where such authority has been established and can be exercised. So that means the situation in the territory must be relatively stable and that the authorities are sufficiently organized to be able to meet their responsibilities under international law. And this is also expressed in the same idea of the Hague Regulations, where it says that the authority of the legitimate power typically there has been passed into the hands of the occupant. And the ICJ has also itself said that in this regard, this is demonstrating that there must be a shift in power from the so-called legitimate authority to the occupy power. And in the armed activities case, the ICJ there was contemplating whether the armed forces of Uganda were considered as an occupying power in the Democratic Republic of Congo. And the court declared it has to be demonstrated that these forces were not only stationed in particular locations, so they're not just they were just there, but they also substituted their authority for that of the Congolese government. So the ICJ considered that there had to be effective control and thus occupation when, firstly, the ousted government is no longer in a position of exercising its authority, And two, the foreign forces have substituted their own authority for that of the government. So it's not enough that there's an army kind of just there. There actually has to be a substitution of the own kind of authority. Um, but there is still a lot of debate around this. And there's, in the kind of international law and academic debates, there's a lack of consent around this issue in terms of like how much authority is needed. But Article 42 again of the Hague Regulation specifies that the territory is under the authority of a hostile army, and this is usually like the belligerent occupation. So the occupation therefore needs effective control by coercive military means. So it's not just, again, a civilian control of a particular state by a different state, for example, but there needs to be some kind of mechanism of coercive military means. And this, again, scope is very much open debate, subject to a whole heap of controversy, especially due to lots of uncertainties that arise in practice as well. And the kind of one of the scenarios that's really particularly debated is this issue of territorial control exercised by a state from abroad, so without military presence on the ground. And this issue was especially discussed in relation to the situation of the Gaza Strip, which followed the withdrawal of Israeli armed forces in late 2005. And this was after about 40 years of continuous presence and control and occupation in the Gaza Strip. And this was part of a disengagement plan, which was adopted by the Israeli government in mid-2004 and also endorsed by its parliament that year as well. And that plan, the intention was that authorities they were wanting to put an end to their responsibilities vis-a-vis the people living in the Gaza Strip. So they wanted to take away their, basically avoid their responsibilities under international humanitarian law, under the law of occupation for the people of the Gaza Strip. And so when they pulled out, then the question of the debate was, well, should then therefore those measures mark the end of the occupation? Was the physical withdrawal of the Israeli Defense Forces enough to admit that effective territorial control characteristic of occupation did not exist any longer? And this was a debate, and certainly has been for a long period of time. But many, again, this might not be this is certainly not the opinion of all international lawyers on this issue, but there's a large number, and I'd probably say probably the mainstream view is that the answer to this question has always been the negative. And most of this is because the Israeli army has retained substantial authority over the Gaza Strip. Although its troops are not physically deployed in the area, or previously were not physically deployed in the area, that the disengagement plan that was agreed and put forward by the Israeli government clearly stated that Israel was to exercise control over the borders of the territory, as well as over its airspace and over its coastal region. And also that, importantly here, a lot of the international academics and observers have stressed that Israel also had the advantage at any point in time to go into the Gaza Strip at its choosing to maintain public order. And this power was made greater by the very small size of the territory of Gaza and the military means available as well. And as stated by Article 42, subsection 2 of the Hague Regulations, there is an occupation when authority of the hostile army has been established and can be exercised. So this wording can be then interpreted as meaning that potential authority would suffice as evidence of the reality of the occupation. And these views, again, which I would probably submit are were relatively mainstream when it was relevant, but also was prominently also put forward by the UN Secretary General, who said that the actions of the Israeli Defense Force in respect of Gaza has clearly demonstrated that they have the technology to allow an occupying power to effectively control a territory even without military presence. So therefore, the occupation of a territory doesn't always cease when the actual military powers are formally withdrawn, because you can have effective control of a territory which is required under the law of occupation, even from a distance. So this if from taking from that, then the three kind of fundamental principles that the law of occupation is based require the occupying powers to restore and ensure public order and civil life in occupied territories, to respect the local legal system, and respect and protect the individuals and property under its control. Now, finally, and this is just very brief, I promise, because I think I've been going for quite a while already. Again, a really expansive area, but a couple of new important issues I just wanted to touch on. I'm not going to really go into any detail, but just for you to think about and, think for yourself, like how do they apply then in this, rules of international humanitarian law we're thinking about this week is firstly automatic or autonomous, sorry, not semi-automatic, but semi-autonomous weapons. The semi-autonomous weapons, I'm so sorry, are kind of like, combat drones. And the idea is that these are supposed to be more precise and proportionate. And combat drones as the kind of key semi-autonomous weapons were presented at the start of the War on Terror, especially as the preferred weapon of the US-backed forces, because the idea was that you'd not only be saving the lives of the drone operators who are obviously not in danger, which was positive and one of the main reasons to use drones, but also the idea was that if you were targeting an alleged militant, an alleged military target, then the semi-autonomous weapons would help make sure that the response was more precise and proportionate. So the US very famously kind of was one of the early initiators of this technology, where they would use drone attacks against people in Pakistan, Yemen, Somalia, Afghanistan, Iraq, many regions around the world, especially focused on the Middle East. However, even though the technology had a reputation, and certainly a theoretical one, for precision, for example, there was and continues to be a lot of evidence to the contrary, that the drone attacks amounted to a whole loss of innocent lives during it. And this was also really exposed in the WikiLeaks scandal that Julian Assange and other people involved in WikiLeaks helped to bring to light, which really visually demonstrated drone operators hitting targets that were much broader than military ones. So the actual practices of combat drones are seriously questioning the theoretical precision proportionality that they are supposed to bring to warfare, again, which creates issues and tensions of international humanitarian law. Now, kind of expanding on that, and we're seeing this a lot more now, the more recent issue of autonomous weapons. And so this is a relatively new term and a relative term, and it may range from launching a weapon to the point of successfully selecting, engaging, and neutralizing a target. The US Department of Defense considers a weapon as autonomous when, once activated, it can then select and engage targets without further intervention by a human operator. But obviously, as we've been speaking about, semi-autonomous weapons have a human operator, which then helps decide then who decides, what enemy combatants they're targeting. But this new development of autonomous weapons, which is now infused by artificial intelligence, challenges a lot of the cardinal principles in international humanitarian law, especially that of humanity and potentially that of proportionality. So it's obviously very important, as we've been discussing, not only in customary law, but also the treaties themselves, that there has to avoid excessive physical and material damage in warfare, which then, by the inherentness of this, needs efficient decision making. But autonomous weapons, which are based on huge amounts of data feed, which reach decisions in a blink of an eye, a snap second, this undermines the role of human judgment, which then means there's probably less capability to potentially make that distinction. And because a lot of the time, these algorithms which are fed into autonomous weapons are based on image classifications, whether they're like soldier uniforms, insignias, viewing weapons and ammunitions. There's potential, for instance, that can be hacked, maybe fed with different image classifications. Maybe images can be misinterpreted by non-autonomous weapons as well. So there's a lot of emerging issues with autonomous weapons, and it's a really new area of research. But I just wanted to kind of like get you to, again, I'm not going into any kind of detail whatsoever, but just get you to think about, how do these new developments interact with international humanitarian law in terms of what we've been speaking about so far. Now, that is it for today. I know there's a bit of a long one, and I apologize for that, but there's an awful lot of content to cover. And in tutorials this week, we'll be doing hopefully a good activity that I hope I've designed where we will be following the development of a hypothetical conflict, and we will be practitioners of the International Committee of the Red Cross, the experts in international humanitarian law, in a kind of internal conference where we're going to be debating and identifying the breaches of international humanitarian law as a conflict develops in time. That's the idea anyway. But thank you everyone too for your engagement last week in tutorials. For those who were there, we played some board games and tried to make them more internationally law relevant. I think that was a nice mix of both being fun and stressful, which I think some of you appreciated, maybe some of you less so. But hopefully it was still a memorable way of doing the use of force. But anyway, I won't keep us any longer. I look forward to seeing you in week 10 for our second last class of tutorials. So thank you so much, everyone, and I'll see you soon.